Continuing on a summary view of the rights of British America, but that one other act passed in the same seventh year of the reign, having been a peculiar attempt, must ever require peculiar mention. It is entitled An Act for Suspending the Legislature of New York. One free and independent legislature hereby takes upon itself to suspend the powers of another free and independent as itself, thus exhibiting a phenomena unknown in nature, the creator and creature of its own power. Not only the principles of common sense, but the common feeling of human nature must be surrendered up before His Majesty's subjects. Here can be persuaded to believe that they hold their political existence at the will of the British Parliament. Shall these governments be dissolved, their property annihilated, and their people reduced to a state of nature at the imperious breath of a body of men whom they never saw, in whom they never confided, and whom they have no power to punish or removal? Let their crimes against the American public be ever so great. Can any one reason be assigned why 1,000 or why 160,000 electors in the island of Great Britain should give law to 4 millions in the States of America, every individual of whom is equal to every individual of them in virtue, in understanding, and in bodily strength? Were this to be admitted instead of being a free people, as we have hitherto supposed and mean to continue ourselves, we should suddenly be found the slaves not of one, but of 160,000 tyrants, distinguished too from all others by this singular circumstance, that they are removed from the reach of fear, the only restraining motive which may hold the hand of a tyrant. That by an act to discontinue in such manner, and for such time as are therein mentioned, and landing and discharging, lading or shipping of goods, wares, and merchandise, at the town and within the harbor of Boston, in the province of Massachusetts Bay, in North America, which was passed at the last session of British Parliament. A large and populous town whose trade was their sole subsistence was deprived of that trade and involved in utter ruin. Let us for a while suppose the question of right suspended in order to examine this act on the principles of justice. An act of Parliament had been passed imposing duties on teas to be paid in America, against which act the Americans had protested as inauthoritative. The East India Company, who till that time had never sent a pound of tea to America on their own account, stepped forth on that occasion, the assertors of the parliamentary right, and sent hither many ships loaded with that obnoxious commodity. The masters of their several vessels, however, on their arrival in America, wisely attended to admonition and returned with their cargoes. In the province of New England alone, the remonstrances of the people were disregarded, and a compliance, after being many days waited for, were flatly refused. Whether in this the master of the vessel was governed by his obstinacy, or of his instructions, let those who know say. There are extraordinary situations which require extraordinary interposition. An exasperated people who feel that they are possess power are not easily restrained within the limits of strict regular. A number of them assembled in the town of Boston, threw the tea into the ocean, and dispersed without doing any other act of violence. If in this they did wrong, they were known and were amenable to the laws of the land, against which it could not be objected that they had ever in any instance been obstructed or diverted from their regular course in favor of popular offenders. They should therefore not have been distrusted on this occasion. But that ill-fated colony had formerly been bold in their enmities against the House of Stuart, and were now devoted to the ruin by that unseen hand which governs the momentous affairs of this great empire. On the partial representations of a few worthless ministerial dependents, whose constant office it has been to keep the government embroiled, and who, by their treacheries, hope to obtain the dignity of the British knighthood, without calling for a party accused, without asking a proof, without attempting a distinction between the guilty and the innocent, and the whole of that ancient and wealthy town is in a moment reduced to opulence from opulence to beggary. Men who had spent their lives in extending the British commerce, who had invested in that place the wealth their honest endeavors had merited, found themselves and their families thrown at once on the world of subsistence by its charities. Not a hundredth part of the inhabitants of that town had been concerned in the act complained of. Many of them in Great Britain and other parts beyond sea, yet all were involved in one indiscriminate ruin by a new executive power unheard of till then, that of a British Parliament, a property of a value of many millions of money sacrificed in revenge could not repay. The loss of a few thousands. This is administering justice with a heavy hand indeed. And when is this tempest to be arrested in its course? 2 wharfs are to be opened again when His Majesty shall think proper. The residue which lined the extensive shores of the Bay of Boston are forever interdicted the exercise of commerce. This little exception seems to have been thrown in for no other purpose than that of setting a precedent for investing His Majesty with legislative powers. If the pulse of his people shall beat calmly under this experiment, another and another will be tried, till the measure of despotism be filled up. It would be an insult on common sense to pretend that this exception was made in order to restore its commerce to that great town. The trade which cannot be received at 2 wharfs alone must, of necessity, be transferred to some other place to which it will to which it will soon be followed by that of the two wharfs. Considered in this light, it would be an insolent and cruel mockery at the annihilation of the town of Boston. By the active suppression of riots and tumults in the town of Boston, passed also in the last session of Parliament, a murder committed there is, if the governor pleases, to be tried in the court of King's Bench, in the island of Great Britain, by a jury of Middlesex. The witnesses, too, on receipt of such a sum as the governor shall think it reasonable for them to expend, are to enter into, recognize, to appear at trial. This is, in other words, taxing them to the amount of their recognizance, and the amount may be whatever the governor pleases. For who does his majesty think can be prevailed on to cross the Atlantic for the sole purpose of bearing evidence to a fact? His expenses are to be borne indeed, as they shall be estimated by a governor, but who are to feed the wife and children whom he leaves behind, and who have no other substance but his daily labor. Those epidemical disorders, too, so terrible in a foreign climate, in the cure of them to be estimated among the articles of expense, and their danger to be warded off by the almighty power of Parliament. And the wretched criminal, if he happen to have offended on the American side, stripped of his privilege of trial by peers of his vicinage, removed from the place where alone full evidence could be obtained, without money, without counsel, without friends, without exculpatory proof, is tried before judges predetermined to condemn. The cowards who would suffer a countryman to be torn from the bowels of their society in order to be thus offered a sacrifice to parliamentary tyranny, would merit that everlasting infamy now fixed on the authors of the act. A clause for a similar purpose had been introduced into an act passed in the 12th year of His Majesty's reign, entitled An Act for the better securing and preserving of His Majesty's dockyards, magazines, ships, ammunitions, and stores, against which, as meriting the same censures, the several colonies have already protected. That these are the acts of power assumed by a body of men foreign to our Constitution and unacknowledged by our laws, against which we do, on behalf of the inhabitants of British America, enter in there our solemn and determined protest, and we do earnestly entreat His Majesty, as yet the only mediatory power between the several states of the British Empire, to recommend to his Parliament of Great Britain the total revocation of these acts, which, however nugatory they be, may yet prove the cause of further discontents and jealousies among us. That we next proceed to consider the conduct of His Majesty and as holding the executive powers of the laws of these states, and mark out his deviations from the line of duty. But the Constitution of Great Britain, as well as of the several American states, His Majesty possesses the power of refusing to pass into a law any bill which has already passed the other two branches of legislature. His Majesty, however, and his ancestors, conscious of the impropriety of opposing their single opinion of let's see conscious of the impropriety of opposing their single opinion through the united wisdom of two houses of parliament, while their proceedings were unbiased by interested principles for several ages past, have modestly declined to exercise this power in that part of his empire called Great Britain. But by change of circumstances, other principles than those of justice simply other principles than those of justice simply have obtained an influence on their determinations. The addition of new states to the British Empire has produced an addition of new and sometimes opposite interests. It is now therefore the great office of His Majesty to resume the exercise of his negative power, and to prevent the passage of laws by any one legislature of the empire which might bear injuriously on the rights and interests of another. Yet this will not excuse the wanton exercise of this power which we have seen His Majesty's practice on the laws of the American legislatures. For the most trifling reasons, and sometimes for no conceivable reason at all, His Majesty has rejected laws of the most salutary tendency. The abolition of domestic slavery is the great object of desire in those colonies where it was unhappily introduced in their infant state. But previous to the enfranchisement of the slaves it is necessary to exclude all further importations from Africa. Yet our repeated attempts to effect this by prohibitions and by imposing duties which might amount to a prohibition have been hitherto defeated by His Majesty's negative, thus preferring the immediate advantages of a few African courtiers to the lasting interests of the American states and to the rights of human nature, deeply wounded by this infamous practice, nay, the single imposition of an interested individual against a law was scarcely ever known to fail of success, though in the opposite scale were placed the interests of a whole country. That this is so shameful an abuse of a power trusted by His Majesty for other purposes, as if not reformed would call for some legal restrictions. With equal inattention to the necessities of his people here, has His Majesty permitted our laws to lie neglected in England for years, neither confirming them by his assent nor annulling them by his negative, so that such of them as have not suspending clause we hold on the most precarious of all tenures, His Majesty's will, and such of them are suspended themselves till His Majesty's assent be obtained. We have feared might be called into existence at some future and distant period, when time and change of circumstance shall have rendered them destructive to His people here. And to render this grievance still more oppressive, His Majesty, by his instructions, has laid his governors under such restrictions that they can pass no law of any moment unless it have such suspending clause, so that, however immediate may be the call for legislative interposition, The law cannot be executed till it has twice crossed the Atlantic, by which time the evil may have spent its whole force. But what in terms reconcilable to majesty and at the same time to truth shall we speak of a late instruction to His Majesty's Governor of the colony of Virginia, by which he is forbidden to assent to any law for the division of a country unless the new country will consent to have no representative in assembly. The colony has as yet fixed no boundary to the westward. Their western countries, therefore, are of indefinite extent. Some of them are actually seated many hundreds miles from their eastern limits. Is it possible, then, that His Majesty can have bestowed a single thought on the situation of those people who, in order to obtain justice for injuries, however great or small, must, by the law of that colony, attend their county court, at such a distance, with all their witnesses monthly, till their litigation be determined? Or does His Majesty seriously wish to publish it to the world, that his subjects should give up the glorious right of representation, with all the benefits derived from that, and submit themselves the absolute slaves of his sovereign will? Or is that rather meant to confine the legislative body to their present numbers, that they may be the cheaper bargain whenever they shall become worth a purchase? One of the articles of impeachment against Tressilian and the other judges of Westminster Hall in the reign of Richard II, for which they suffered death as traitors to their country, was that they had advised the king that he might dissolve his parliament at any time, and succeeding kings have adopted the opinion of these unjust judges. Since the establishment, however, of the British Constitution at the glorious Revolution on its free and Antonian principles, neither His Majesty nor his ancestors have exercised such a power of dissolution in the island of Great Britain. And when His Majesty was petitioned by the united voice of his people there to dissolve the present Parliament, who had become obnoxious to them, his ministers were heard to declare in open Parliament that His Majesty possessed no such power by the Constitution. But how different their language and his practice here, to declare, as their duty required, the known rights of their country, to oppose the usurpations of every foreign jurisdiction, to disregard the imperious mandates of a minister or governor, have been the avowed causes of dissolving houses of representatives in America. But if such powers be really vested in His Majesty, can he suppose they are there placed to awe the members of from such purposes as these? When the representative body have lost the confidence of their constituents, when they have notoriously made sale of their most valuable rights, when they have assumed to themselves powers which the people never put in their hands, then indeed their continuing in office becomes dangerous to the state, and calls for an exercise of the power of dissolution, such being the causes for which the representative body should and should not be dissolved. Will it not appear strange to an unbiased observer that that of Great Britain was not dissolved, while those of the colonies have repeatedly incurred that sentence? But your majesty or your governors have carried this power beyond every limit, or provided for by the laws, after dissolving one House of Representatives, dissolving one House of Representatives, they have refused to call another, so that for a great length of time the legislature provided by the laws has been out of existence. From the nature of things, every society must at all times possess within itself the sovereign powers of legislation. A feeling of human nature revolt against the suppositions of a state so situated as that it may not in any emergency provide against dangers which perhaps threaten immediate ruin. While those bodies are in existence to whom the people have delegated the power of legislation, they alone possess and may exercise those rights, but when they are dissolved by the lopping off one or more of their branches, the power reverts to the people, who may exercise it to unlimited extent, either assembling together in person, sending deputies, or in other way they may think proper. We forbear to truce consequences further. The dangers are conspicuous with which this practice is replete. That we shall at this time also take notice of an error in the nature of our land holdings, which crept in at a very early period of our settlement. The introduction of the feudal tenures into the kingdom of England, though antient, is well enough understood to set this matter in a proper light. In the early ages of the Saxon settlement, feudal holdings were certainly altogether unknown, and very few, if any, had been introduced at the time of the Norman conquest. Our Saxon ancestors held their lands, as they did their personal property, in absolute dominion, disencumbered with any superior answering nearly to the nature of those possessions which the feudalists term allodial. William the Norman first introduced this system generally. The lands which had belonged to those who fell in the battle of Hastings and in the subsequent insurrections of his reign formed a considerable portion of the land of the whole kingdom. These he granted out, subject to feudal duties, as did he also those of a great number of his new subjects, who, by persuasions or threats, were induced to surrender them for that purpose. But still much was left in the hands of his Saxon subjects, held of no superior and not subject to feudal conditions. These, therefore, by express laws enacted to render uniform the system of military defense, were made liable to the same military duties as if they had been feuds, and the Norman lawyers soon found means to saddle them also with all the other feudal burthens. But still they had not been surrendered to the king. They were not derived from his grant, and therefore they were not holden to him. A general principle indeed was introduced that all lands in England were held either immediately or intermediately of the crown, but this was borrowed from those holdings which were truly feudal and only applied to others for the purpose of illustration. Feudal holdings were therefore, by exceptions out of the Saxon laws of possession, under which all lands were held in absolute right. These, therefore, still form the basis or groundwork of the common law to prevail wheresoever the exceptions have not taken place. America was not conquered by William the Norman, nor its lands surrendered to him or any of his successors. Possessions there are undoubtedly of the allodial nature. Our ancestors, however, who migrated hither were farmers, not lawyers. The fictitious principle that all lands belong originally to the king, they were early persuaded to believe real, and accordingly took grants of their own lands from the crown. And while the crown continued to grant for small sums and on reasonable rents, there was no inducement to arrest the error and lay upon to public view. But His Majesty has lately taken on him to advance the terms of purchase and of holding to the double of what they were, by which means, the acquisition of lands being rendered difficult, the popularity of our country is likely to be checked. It is time, therefore, for us to lay this matter before His Majesty, and to declare that he has no right to grant lands of himself. From the nature and purpose of civil institutions, all the lands within the limits which any particular society be circumscribed around itself are assumed by that society and subject to their allotment only. This may be done by themselves, assembled collectively, or by their legislature, to whom they may have delegated sovereign authority, and, if they are allotted in neither of these ways, each individual of the society may appreciate to himself such lands as he finds vacant, and occupancy will give him title. That, in order to enforce the arbitrary measures before complained of, His Majesty has from time to time sent among us large bodies of armed forces, not made up of the people here, nor raised by the authority of our laws. Did His Majesty possess such rights as this, it might swallow up all our other rights whenever he should think proper. But His Majesty has no right to land a single armed man on our shores, and those whom he sends here are liable to our laws made for the suppression and punishment of riots, routs, and unlawful assemblies, or our hostile bodies invading us in defiance of law. When in the course of the late war it became expedient to a body of Hanoverian troops should be brought over for the defense of Great Britain, His Majesty's grandfather, our late sovereign, did not pretend to introduce them under any authority he possessed. Such a measure would have given just alarm to his subjects in Great Britain, whose liberties would not be safe if armed men from another country and another spirit might be brought into the realm at any time without the consent of their legislature. He therefore applied to Parliament, who passed an act for that purpose, limiting the number to be brought in and the time they were to continue. In like manner, in His Majesty's restrained in every part of the empire. He possesses indeed the executive power of the laws in every state, but they are laws of the particular state, which he is to administer within that state, and not those of any one within the limits of another. Every state must judge for itself the number of armed men which they may safely trust among them, of whom they are to consist, and under what restrictions they shall be laid. To render these proceedings still more criminal against our laws, instead of subjecting the military to the civil powers, His Majesty has expressly made the civil subordinate to the military. But can His Majesty thus put down all laws under his feet? Can he erect a power superior to that which erected himself? He has done it indeed by force, but let him remember that force cannot give right, that these are our grievances, which we have thus laid before His Majesty, with that freedom of language and sentiment which becomes a free people proclaiming their rights as deriving from the laws of nature, and not as a gift of their chief magistrate. Let those flatterer who fear it is not an American art to give praise which is not due might be well from a venal, but would ill beseem those who are asserting the rights of human nature. They know, and will therefore say, that the kings are the servants, not the proprietors of the people. Open your breast, sire, to liberal and expanding thought. Let not the name of King George III be a blot in the page of history. You are surrounded by British councillors, but remember that they are parties. You have no ministers for American affairs, because you have not taken from among us, nor amenable to the laws on which they are to give you advice. It behooves you, therefore, to think and to act for yourself and your people. The great principles of right and wrong are legible to every reader. To pursue them requires not the aid of many counselors. The whole art of government consists in the art of being honest. Only aim to do your duty, and mankind will give you credit where you fail. No longer persevere in sacrificing the rights of one part of the empire to the inordinate desires of another, but deal out to all equal and impartial right. Let no act be passed by any one legislature which may infringe on the rights and liberties of another. This is the important post in which fortune has placed you, holding the balance of a great, if a well-poised empire. This, sire, is the advice of your great American Council, on the observance of which may perhaps depend your felicity and future fame, and the preservation of that harmony which alone can continue both to Great Britain and America, the reciprocal advantages of their connection. It is neither our wish nor interest to separate from her. We are willing on our part to sacrifice everything with reason, which reason can ask, to the restoration of that tranquility for which all must wish. On their part, let them be ready to establish union and a generous plan. Let them name their terms. Let them be just. Accept every commercial preference it is in our power to give for such things as we can rise for their use, or they make for ours. But let them not think to exclude us from going to make markets to dispose of those commodities which they cannot use, or to supply those wants which they cannot supply. Still less, let it be proposed that our properties within our own territory shall be taxed or regulated by any power on earth be our own. The God who gave us life gave us liberty at the same time. The hand of force may destroy but cannot disjoin them. This, sire, is our determined resolution, and that you will be pleased to interpose with the efficacy which your earnest endeavors may ensure to procure redress of these our great grievances, to quiet the minds of your subjects in British America against any apprehensions of future encroachment, to establish fraternal love and harmony through the whole empire, and that these may continue to the latest ages of time, is the fervent prayer of all British America.